This is TWiT.
All right, big story. Actually, we probably should have led with this. The Supreme Court is going to hear, I think, a very interesting case. I wish I had been trained as a lawyer. I know one of the things you do in a lawyer is, as a lawyer in your training, is you learn how to state the facts of a case in a coherent, succinct way, and then you can talk about the merits of it and the pros and cons. I'm going to do my best, but it won't be very good. The case is, I'm just warning you ahead of time. The case is Gonzalez versus Google. The Supreme Court has agreed to hear it. I'm not sure. The arguments haven't happened yet, but we're starting to see briefs from all the big tech companies come in. At the root of the case is a family, the Gonzalez family in France, whose daughter was killed in 2015 in a Paris bistro. You probably remember this 2015 ISIS terrorist attack. Noemi Gonzalez. The reason they're suing Google in this is because ISIS allegedly relied on YouTube to recruit before the attack. So the family has sued to hold Google liable for aiding and abetting terrorists. Their contention is that the Google recommendation algorithm radicalized young people and turned them into terrorists with these ISIS videos. Google says, of course, well, we take those videos down the minute we find them. But they're not denying the algorithm. They are saying we are protected under Section 230. And really, that's why this is a very important case. Section 230 of the Digital Millennium Copyright Act, DMCA, written by Ron Wyden, to protect the internet. It's very simple. It really is. It's two rights. One, the right to not be liable as a company. For instance, I'll give you the immediate example to me. We have an IRC chat room. We have a Discord chat. We have forums at twit.community. We have a Mastodon at twit.social. I would be liable, and I could be sued by anybody for stuff posted there, except that Section 230 makes me immune to prosecution and immediately causes the suit to be dropped. The judges say, no, you're protected. That's part one. Part two of my rights, it also gives me the right to moderate. And this is very important. Without the protection, there's the risk of taking down, let's say, Donald Trump's account, or as I do often, taking down hate speech in our Mastodon instance, would also open me to liability. That person could sue me for taking that down, and maybe I'd win in court, but I'd have to defend it in court. Section 230 means I don't have to defend it. So Section 230 is very important to the internet. We've talked about it a lot. The part of the problem, I think, here is that it is being associated with the big tech giants. Google and Meta, Twitter, everybody is signing on to amicus briefs, friends of the court briefs, why the Supreme Court should not do this. I love this one. The Supreme Court just yesterday, I think, allowed, or maybe it was Friday, Reddit mods to anonymously comment on this in Reddit's amicus. The reason being, Reddit mods use algorithms all the time to moderate their individual subreddits. But many of them are anonymous, and so normally in an amicus brief you sign it, and Reddit went to the Supreme Court saying, can we have anonymous, because our moderators want to stay anonymous for a good reason in many cases, can we allow their comments? And the Supreme Court said yes. Yes, the Sophia Cope of the EFF said, we're happy the Supreme Court recognized the First Amendment rights of Reddit moderators to speak to the court about their concerns. So, actually, I should mention that R Street, which is the lobbying organization, the Shoshana, are you an employee or a contractor for them? I should get that straight.
Oh, employee. And we're technically a think tank because sometimes we just put out ideas. Sometimes we're like, hey, please do this, or hey, please don't do this. It varies on the day.
So it's more you. And in fact, this comes from Jonathan Cannon, your policy counsel. So this is more an amicus brief of why Section 230 should be protected.
Yeah.
But you take a kind of an interesting point of view. So petitioners claim that a test has been used by the lower courts to resolve 230's cases to say that YouTube's recommendation algorithms are not protected. And I have to say, I'm not sure about this. Boy, I know I need Section 230 because we would not have a chat room or forums or Mastodon if Section 230 didn't exist, because it would put me out of business. I'd have to defend frivolous lawsuits right and left. So I'm in favor of 230, but I kind of understand the family's point of view that Google did more than just, is Google's recommendation, in effect, taking an editorial position on this stuff, I think maybe should make them liable. And so that's why this initial test, that it's a traditional editorial function test. Now, your counsel said both theories are wrong. Petitional's traditional editorial functions test is unsupported by the text of 230. That's true. 230 is very clean and simple. It's almost like a constitutional amendment. It's very good. It is also, he says, not consistent with lower court decisions that purportedly make use of it. The conventional three-pronged Barnes test, which lower courts typically use to determine whether Section 230 applies, is a much better fit. So he's kind of lobbying for this Barnes test. I should probably read up on this. He doesn't describe what the Barnes test, but he does say Google's algorithmic recommendations satisfy all three prongs and thus are entitled to Section 230. YouTube's labeling of relevant videos with the words "up next" does not void 230 protection, just as a newspaper guiding readers to the remainder of a front page story would not void that paper's legal protections. I don't know if "up next" is exactly the same as continued on page 25. Canon says so. Nor does YouTube lose Section 230 protection for arranging its site in a way that is navigable and relevant for users. That makes sense. A newspaper does not waive otherwise applicable legal protections for publishing an article when it puts it on the front page. YouTube does not lose protections for hosting a video when its algorithm makes that video up next. I feel a little funny about that one. And he says even if recommendations were distinct pieces of content rather than necessary byproducts of organizing content, these recommendations would be generated by user inputs subject to neutral algorithmic rules and thus not speech developed by YouTube. I would contend those are not neutral rules, that the rules are, in fact, to optimize for profit by optimizing for engagement. Yeah. And I don't think that is neutral. Finally, he says a ruling for petitioners would lead to dire consequences for online speech. This I agree with, thwarting the purpose of Section 230. So R Street is in favor of keeping 230 intact, as are, of course, all the big tech companies. So I think this is a fascinating subject. I've done a terrible job. I would get a C- in law school. But that's my statement of the case, of the facts of the case, and my thoughts about it. Patrick, go ahead. Shoshana, you should start, because this is your brief.
Sure. So I actually didn't know we were going to talk Section 230 today, but I'm still wearing my Section 230 necklace because I'm obsessive. And I really like the law, and especially for someone so free market as I don't often like laws, but I do think it was very well written. Also,
in a way, it preserves the free market, right? It means
exactly
that the free market of ideas can exist.
Right, exactly. And also, you had one error that I'm going to call you out on. You said that it was part of the DMCA, and it was part of the Communications Decency Act of 1996.
CDA. I apologize.
You're fine. There's a million acronyms, and I just thought
that's
it's funny.
Exactly right. Yeah.
But we've done work on the DMCA too, which is why I'm like, oh, I know what that is.
Yeah.
But I think with algorithms, there's a bunch of different things to consider for how Section 230 applies. And one thing that I really love that you're talking about is that it applies to all sizes of things, that it's not just the bigger tech companies. But Facebook in the past, or Meta technically, has actually lobbied to kind of sideline 230 in certain cases. So some of the larger tech companies disagree on like how 230 should work, where it should apply. For me, I'm genuinely for it for the smaller platforms, because we see the way Twitter is going, like we were talking about before. I want competitors, and I want to make sure that, there's an incumbent advantage, but 230 makes it so that there's a little bit less of that, because without 230, these smaller platforms like Mastodon doesn't have a huge team of lawyers.
Nor does Leo.
Sort of.
And I don't know if Mastodon would be liable if something bad were posted on Leo's instance. I think I would be liable, probably Mastodon as well. So
that's part of it, the layers of liability there.
Right.
And with algorithms in particular, algorithms are speech. So you can be liable for your own speech. Like Twitter's liable for its own writing and its own content, just not for user content. But as far as how it impacts an event here, like how an algorithm impacts an event, the inputs weren't optimizing for like the worst of the worst content. It wasn't trying to do that. And also part of it, I guess, is that, people on their own will find the content they want to find. Awful stuff and conspiracy theories spread on the internet long before algorithms were in use. And because of that, I think sometimes people tend to demonize algorithms more than they deserve. Not to say that there's not problems with them or that there's not ways to improve them or make them safer and make them better. But I think sometimes people forget that the demon in the algorithm is the person it's optimizing for, which it could just be a regular user. But in this case, I just don't think the other side has a really strong case that these items were connected, that it was the specific terrorists, that it was terrorists broadly who were, radicalized by YouTube.
Yeah, and the court may end up saying, well, you don't have standing. This isn't, sure. These aren't people who were involved, blah, blah, blah. But it does raise a very interesting issue. And I guess my issue is that an algorithm to optimize profitability through creating more engaging or showing more engaging content tends to move towards extremes. We've seen that. And I worry that is problematic, right? What I don't want to do is lose 230 protections. I also understand that algorithms are used in a variety of ways. These Reddit moderators say, look, we use algorithms all the time, not in that way, but we use them all the time to protect the subreddits. We don't want to have that tool taken away from us. I understand that. But I feel like Google's a little liable for surfacing content that is more profitable because it's more engaging and hence more extreme.
Well, it does surface, but I think one key element, I'm bumping into my desk, sorry. One key element is how good a job are they doing at policing this and removing the objectionable content. And I don't know how well they were doing at that in 2015 and a few years before. But I really think, from what I know of the platform, that nowadays they're doing a pretty decent job, partly motivated by rules in the EU that state, you have to remove something within 24 hours of it being, of you being notified. And I think that you're never going to have any form of media or platform, because we're talking about the internet, where user-generated content can appear that is going to be completely clean. That is just impossible. Anyone saying otherwise is, I think, wrong. And if Google is doing an earnest job at policing the platform, maybe, we could argue that maybe they're not in certain instances. But I think for things that are related to terrorism and child pornography, they're probably doing their darnest.
They say, and I think they're right. They try to take those videos down as soon as they find them. They take them down. I mean, they're doing everything they can. So I'm not faulting them for that, but I do feel like, and again, the word algorithm is probably a bad choice because algorithms can mean a lot of things. It just means a computer program. But I do feel like there's a danger to algorithms, to programs that surface content because it's more engaging, hence more profitable. I mean, that seems to me to be a little different from what people are doing on Reddit, what Mastodon's doing with the trending topics. That seems different, but maybe it's not. Maybe it's not under the law different enough that we can allow it.
The problem is that algorithms optimizing for engagement is kind of an emergent property of you trying to offer good user experience to your users. You know, what those algorithms do is show stuff that people like to watch.
Right.
So again, it becomes an issue of, I think. So that's part of it. But the other question, if you'll allow me to give another angle to this, let's study for a second what happens if you do remove 230. Because the web today is largely a user-generated content-powered web. And if you remove Section 230, I think you're right. In an instant, those businesses are threatened, very much threatened.
It turns into a bunch of Coca-Cola ads and stuff. I mean, it's just not.
Not just Coca-Cola ads. User-generated web, I'm not sure can survive. So what you end up
YouTube
with
goes away.
Is institutional media and no small guy or gal. You only have big companies that can afford to produce content and to have websites. And that is, I think, the biggest, because again, we don't like Nazis. And I think there are a lot of issues currently with them abusing the Section 230 essentially-ness of the web to be able to be there and proliferate. I still don't think we should remove user-generated content, which I don't think it's it's so big, Section 230. I don't think it's unreasonable to say if the Supreme Court rules a certain way, the user-generated web is threatened. And that's a very concerning prospect for me, because you're left with, big companies, and that's it. You don't have anything else on the internet.
Yeah.
Is that an iPhone in your hand? Wait a second. Is that an Apple Watch on your wrist? And do I see an iPad sitting there on the table? Oh my goodness! You are the perfect person to be watching iOS Today, the show where Rosemary Orchard and I, Micah Sargent, talk all things iOS, tvOS, watchOS, HomePod OS. It's all the OSs that Apple has on offer, and we show you how to make the most of those gadgets. Just head to twit.tv/iOS to check it out.